Thanks so much. I'm Neil Gordon. We appreciate your viewership on this special pre-recorded edition of News 12 Law Call. Tonight's topic, trial lawyers. Let's face it, it is not unusual to hear someone bad-mouthing attorneys. Do you think there are too many lawsuits? Too many lawyers making too much money? Well, besides all the bad press, what do you really know about lawyers and the work that they do for ordinary folks? Tonight we're going to examine some myths and misconceptions about the legal profession. We'll also explain what you should expect from your attorney. Please stay tuned. If you have a question about lawyers, we're going to try to answer some questions that were submitted to us previously. We want to welcome into the program Vic Hawk from the Vic Hawk Law Firm. And hello, sir. How are you?
Doing fine. How about you, Neil?
Fantastic. Just out of curiosity, if you get, let's say, 10 cases that come into the Vic Hawk Law Firm, how many of them might get settled, and how many of them do you like to see through right to the very end?
I would say 9 out of 10 cases get settled, probably a little more than that.
Okay.
What people don't understand is with regard to litigation in the court system, personal injury litigation represents about 5% of all litigation in the courts. The courts are tied up with criminal cases, domestic cases, divorces, child support, adoptions, and probate matters, not civil litigation.
I see, but there are times when you need to not say, okay, I'll take this amount of money, you'll do this, I'll do that. It's important to go to court.
Yeah, it's very important that you go to court, and the reason for it is this, or you at least have a lawyer that can go to court for you. The reason for it is this. Many times, insurance companies are very profit-oriented. A lot of times we can't settle claims until the end of the year because the insurance accounting system is set up so that they can hold your money that you're entitled to for a full year, and then just prior to the end of the year, they start ringing our phones off the wall to try to get claims settled. If you don't use a trial lawyer, they have no threat to try to settle the claim any earlier. If you don't use a trial lawyer, they try to wholesale sell the claims at the end of the year. If you have a trial lawyer, you can go ahead and get that process started immediately. They are interested in settling a case if they understand and know that they have the potential for it costing them money. If they have to hire a lawyer to defend the claim, then they consider settling it. If you send them notice of the claim, they consider settling it. If they go through discovery, they reconsider settling the case.
Sure.
There's a requirement that mediation is done just prior to trial. They reconsider settling it. When the trial starts, they'll increase their offer again. We had them do it just this last month in Savannah. We're about to try a case. We went through mediation. Before mediation, they offered nothing. At mediation, they offered some money. At trial, they offered some money. None of it was reasonable, but the end result was we got an extremely good result for the client.
And in your actual law firm, there's not one, there's not two, there's 3 trial attorneys.
Absolutely. And trial attorneys are very important to have on your side. I brought Reed Sanders with me tonight, who is also a trial attorney. We go to the seminars, we go to the schools that teach you how to protect your people in a court. Reed, can you explain to our viewers why it's important to have a trial lawyer in a setting where you have an injury claim like this?
Sure. Vic, you touched on it a lot, but I think the main thing is the threat of it going to trial is huge when it comes to insurance companies. You know, the main job for an insurance adjuster is to pay as little money as possible. That's the bottom line. So if they know that you are not going to go to trial and that you're going to ship that case out, then they're just not going to up that offer. But if they know when push comes to shove, if you're going to take that case and try that case, then they're more inclined to give you a better offer. And that's why, you know, we can get some cases settled that some other places may not, because we can go to trial if we need to.
And if you think about it, what's a better way to resolve a claim if two two parties can't agree to go to 12 persons that have absolutely no contact with any of the parties in the case, the facts of the case, circumstances of the case, and let them decide what's fair to do under the circumstances. And you completely lose that unless you use a trial lawyer.
Well, we have several questions submitted in via graphics. We want to go to the first one. We'll let Reed take this because Reed was a high school football star and he had to make a big choice. And the first question is, all right, Reed, why did you decide to go to law school?
Well, that's a long, complicated answer, but
We're glad you did.
yeah. I guess the long and the short of it's going to be to help people. I think that's why every lawyer goes to law school. And I think, the public loses sight of that, because there's a bad apple in the bunch. But most attorneys are people that want to help people. And that's why they go to law school, and that's why they become attorneys. If you don't want to help people, then you're probably not going to make it. But that's my reason. I'm sure Vic's is very similar to that, but the main reason is to get into an arena that you can make a difference in people's lives.
Mm-hmm. And you'll see that time and time and time again at lawyers' conferences that we go to. We spend hours, days training to how we can better help people. We share ideas. In the Georgia Trial Lawyers Association, one of the things you hear time and time and time again, although we fight or compete to receive cases where we can help people, once that is done, our number one interest is figuring out the best way to get the best result to actually help people. It's not to necessarily make money. You always want to be successful in what you do, and as a result, the measures of success are different with different lawyers. But our number one interest is to care about the client and to get the best result possible for them under a bad situation.
Mm-hmm. Well, our next question, Vic touched on a little bit earlier on, but the question has to do with sort of the differences, I suppose, between what a trial lawyer is and how a trial lawyer's work might differ from other types of lawyers. And there you see it up on the screen. I mean, you're aware, you see a lot of the television advertising and so forth, and I suppose in some cases it's a bit of a numbers game, and the clients become sort of a number, a way for attorneys to make money.
That's exactly right, Neil, and that's something that we want to stop. We don't want the public's suffering to be wholesaled. We want them to be fully protected. A lot of times you see in advertising speed, convenience with regard to resolution of claims, and that's not necessarily in the best interest of the client. And in many times it's not. But most importantly, the only way in dealing with the other side, which is the insurance industry, that you have any measure of strength against them is to have a trial lawyer. There's a difference between a trial lawyer and I would call it a screener. A trial lawyer is a person who is a member of the Trial Lawyers Associations, goes to the training, goes to the schools that's available to keep you on the cutting edge of being able to help people. If you can't do that, then I generally rephrase that you're getting a half a lawyer. You're really not getting the full benefit of legal representation. It's very important that you do so, and you can only do it with a trial lawyer.
Well, thanks for continuing to watch our topic tonight, the truth about trial lawyers. The show's pre-recorded, so we won't take your calls, but we have some other submitted questions on the other side of the break. You're watching News 12 Law Call. Reed Sanders recorded a special legal brief for us. These days it seems like anytime someone breaks a nail, they'd like to sue someone else for damages. So do injured people have the right to sue always? Personal injury attorney Reed Sanders explains in tonight's legal brief.
People always have the right to sue, but whether they have a case isn't always a slam dunk. Not every injured plaintiff is entitled to recover damages for the injury he or she sustains. The plaintiff must establish that the defendant is legally liable for his or her injuries. Whether legal cause is established depends on the facts and circumstances of the particular case. If someone intentionally causes harm or knows that certain conduct makes it likely that harm will result, they will likely be liable for it. Other personal injury cases carry a looser concept of fault called negligence. If you knowingly or willfully choose to encounter a known hazard, the law holds that you have assumed the risk of the injury, and therefore no one is liable. I'm Attorney Reed Sanders of the Vic Hawk Law Firm. Back to you.
And we're continuing with Reed Sanders and Vic Hawk, and tonight the truth about trial lawyers. And guys, you know sometimes Jay Leno, David Letterman, your profession makes the top 10 list. It's not fair.
They'll be the first ones to call us when they get in trouble.
Right.
Yeah, that's right.
Exactly right.
That's right. But our question has to do about lawyers. Let's take a look at it. What are the most common complaints that you hear about lawyers, and how would you respond to them? We'll get to the question in a moment that's on the screen, but let's start with that. What are some of the more common complaints that you hear about attorneys, Reed?
Well, in the civil side, I would say it's the time that it takes to get a case to trial or to get it resolved. And that can be a twofold type of thing, because if you try to settle it too fast, you can wind up with a bad result because you don't get your full amount of what your claim's worth. But the time that it takes can be extensive because the criminal calendar is going to take precedent over the civil calendar. And that's just because the taxpayers are paying for these people to be in jail. And also, if you're in jail, if you're innocent, you need to get out. So those cases are going to be put in front of a civil case, like a personal injury claim or something like that. So the most of the time when I hear about problems, it's the length of time that it takes for a case to get to trial.
But in some cases, it's really out of the hands of the attorneys. I mean,
Sure.
what do they call it? Dry docket, or it gets delayed?
Yes, dead docket.
Dead docket,
And
sure.
the civil litigation gets pushed behind the criminal litigation. It's very common, but in our circuit and in other circuits around Georgia, the judges are making a concerted effort now to put the civil cases on the criminal calendars, and when the criminal calendars fall through, we're adding those civil cases back into the regular docket call.
Well, our fourth question of our program, The Truth About Trial Lawyers Now, reads like this. With so many lawyers out there, Vic, how can I find the right lawyer to handle my specific legal problem?
I think it's very important that you use your media sources, the telephone book, the radio, the television ads that you see, but you go beyond that and you look to see what specialty area the trial lawyer or the lawyer says he practices in. And then you ask questions about that lawyer. Is he a trial lawyer, or is he a lawyer that just stays in his office and never appears in court? Is he a trial lawyer that's a member of various trial lawyers associations, and is he attending regularly? Is he a lawyer that has tried a case, say, in the last 2 years, and what were the results of his work? All those things would be very important in determining whether you would use that lawyer for that particular type of case. If you're looking for someone to help you with an accident case, look to see if that person is a person that goes to court and is successful in court in helping those that need help.
And of course, the Vic Hawk Law Firm, many of the other firms, of course, belong to the Bar Association. I mean, in business, you've got the Better Business Bureau. Right. How are attorneys monitored in the area? Is there a rating system?
I wouldn't say there's really a rating system. I mean, it's kind of, this bar monitors itself. It's one of the only professions that really does that. And if you get out of line or do something wrong, then the bar can penalize you and have sanctions against you. So I think that the answer to that question is probably it's self-regulated. And as far as the other things like the Georgia Trial Lawyers Association, that kind of thing, that's more of a situation where you get information to help you on certain things, training on certain cases, that type of thing.
Okay. Sounds good. Well, here's what our next questioner has to say. They say that we hear a lot in the media about frivolous lawsuits filed for reasons that seem absurd. So, Reed, are frivolous lawsuits really causing a problem within the legal system?
The answer to that question is no. It's almost with the safeguards that are built into legislation, it's almost impossible to have a frivolous lawsuit, number one. Number two, an attorney's not going to file a frivolous lawsuit because it's costing that attorney money. If there's not a chance to be successful, then there's no reason to go in and spend money and pay the court cost and spend money on your time if the case is not going to be successful. I think that TV and TV shows kind of show those situations where there are frivolous lawsuits, but I just don't see it being a problem, and I don't see it being an issue.
Yes. You have to remember that there are bad apples in every profession.
Right.
And what you're going to see in the media is examples of bad apples when you're talking about frivolous lawsuits. The percentage of those types of lawsuits is extremely small. The lawyer that files a claim like that, number one, is losing money when he starts pursuing it. And number two, there are sanctions that the court can assess against not only his client but also him in the event that they assert a frivolous claim. So there's plenty of protection from being subject to a frivolous lawsuit.
And one more thing I want to touch on that is that you hear about these things on the news and that kind of thing about a frivolous lawsuit. Take a look at that lawsuit. Let's see what really happened in that case. The McDonald's coffee case is one that everybody points to. I challenge you to go look up that case and read the facts of that case. It'll totally change your opinion on what you thought was frivolous and if that case is legitimate, which it is.
McDonald's got hurt by that, and some changes were made, which is good.
Well, you'll be shocked, but with regard to that particular claim, the lady got very little by way of compensation for her injuries, and I'll talk to you more about that on the break.
That's right. And on the other side of the break, we're going to ask these two gentlemen about some important verdicts that have come down in the CSRA. Some real interesting topics ahead. The truth about trial lawyers, a pre-recorded edition of News 12 Law Call after we pay the bills. About the so-called frivolous lawsuits, and the McDonald's coffee spill came up, and boy, that plaintiff had some serious burns.
She did, but I want y'all to understand that in that case, you had 12 jurors looking at the evidence and making a decision based on the evidence. In reality, what occurred was this lady offered to settle for $20,000 prior to trial. She had severe injuries to her genital area, multiple surgeries. The jury came back with an award of $200,000 for her injuries, cut it down to $160,000 because they found her 20% at fault. But the reason the jury got incensed was McDonald's had 700 prior claims of burns to customers due to the temperature of the coffee before this occurred, and they didn't change it. And they knew about the risk, they knew about the hazard, and they still weren't making any accommodation for it. 700 prior claims. The punitive damage award was originally $2.7 million, which represented the sale of coffee for 2 days, and that was eventually reduced to $480,000. While the case was still on appeal, it was settled between the parties.
That brings up something kind of interesting. You mentioned 700 different people. When you get that many numbers together, is that how class action lawsuits form?
It is generally how class action lawsuits are formed, but it's a different context because those individual cases probably would have a lot of different circumstances affecting it. Class actions are where they have common sets of facts. Say, for example, with loan consolidation companies overcharging people for their services. All the individuals would be overcharged the same amount. The loan consolidation company would be breaking the law in the same way in order to gain advantage or gain money.
Okay. Well, we've got two more questions to get to, maybe a minute or so for each of you to respond. Reed, some people claim that tort reform would reduce health care costs and insurance premiums. Is that actually true?
It may, but I don't believe so. The reason for that is that trial lawyers protect people from bad medicine. These medicines that are coming out every day, if they're allowed to come out without any ramification and they start hurting people, then your health care actually goes up. because the healthcare is having to pay for these people who are getting injured and sick, and the trial attorneys can safeguard the public from those problems. So no, having more tort reform will not help keep healthcare lower. It actually get it higher.
You know, actually, according to the Congressional Budget Office, the cost of litigation represents less than 2% of all healthcare costs.
Right.
Less than 2%. So it's not related. And, you know, insurance companies do a really good job of promoting their interest. And for example, you heard a lot about tort reform, which are ways to limit people having access to the court, to let juries determine what's a fair result under the circumstances. What we've learned is this is bogus attempt to restrict the juries in making the determinations as to how to handle claims.
All right, last question for this particular program. For you, Vic or Reed, whoever would like to jump in, is there a verdict that you are particularly proud to have been a part of?
Vic, you go for this one. I know you got a lot more than I do.
Yeah.
So.
The answer is yes. We were able to help a lady that was injured in a store. The company was caught hiding documents where they knew that the particular hazard existed there in the store. She didn't fall to the floor, but she had a very serious back injury, and as a result, we were able to help her get about $200,000 in medical bills paid and compensation for the rest of her life.
That's a great verdict. Thanks to both of you for being part of this, and we'll be back next Sunday night for News 12 Law Call.